Hi, welcome to CLAT chat. I'm getting many mails from the students, means from the aspirants of that is civil service examinations as well as AoR examination. That they are asking for my guidance on how to write notes on familiar cases. Actually, writing a notes, whether it is a brief or in detail, on a familiar case, it is very easy. Means I know that actually that leading cases is one out of four papers for the AoR examinations. So they will supply that judgment copy. So, but actually the only thing is how to prepare the notes, that is the question, because that is very lengthy judgment, so time will not support to read the entire judgment. However, for the students of, means for the aspirants of the civil service examination, they have to write the note, but the judgment copy will not be given to them. They have to, means already they must have some awareness regarding that case to prepare the notes in detail. Okay, for whatever the case it may be, whether it is a familiar case or it is a burning case, whatever the case may be, to prepare the notes on a familiar case, means on the judgment, you have to, means focus on five things. You have to focus on five things. First one, what are the facts of the case? Second one, what are the issues in that case? And the third one, what are the arguments of the petitioner? And the fourth one, what are the arguments of the respondents? And the fifth one is judgment. These five things you have to get, means select from the related case. Means I will explain you by taking the familiar case of Kesvananda Bharti. You see, I told you that to write a notes, whether it is a brief or in detail, you have to focus on five things. First one, facts. Second one, issues. Third one, arguments of the petitioner. Fourth one, arguments of the respondent. And the fifth one, judgment. Now, I will explain you how to write the notes on the case of Kesvananda Bharti. See, it is very difficult to read the entire judgment because nearly there are more than 1300 paragraphs in that judgment, as well as the entire judgment divided as 8 parts. So it is very difficult to read the entire judgment within the short period to write the notes. So first, when you have given a copy of the judgment, first you focus on the facts of the case. Here, in the case of Kesvananda Bharti, the facts of the case are: Kerala government made an act in 1963 in the name of the Kerala Land Reforms Act 1963. By using this act, Kerala government acquired some properties of a religious sect in Kerala. So, the chairman of that religious sect, named Kesvananda Bharti, challenged the action of the Kerala government before the Supreme Court under Article 32. So, here Kesvananda Bharti is the petitioner and the state of Kerala is the respondent. These are the facts of the case. These are the facts of the case. Now, what are the issues? What are the issues means? We have to note that the Kerala Land Reforms Act 1963 was made by the Kerala government or Kerala Assembly based on 24th constitutional amendment made by the Parliament. So, here what are the issues means? The issues are the validity of the 24th constitutional amendment made by the Parliament, and the second one, whether means the power of Parliament to amend the Constitution. These are the issues. So, first, if there is a conclusion or if there is a clarity on these two issues, then the problem may be solved. So, these are the issues. So, what are the issues in the case of Kesvananda Bharti means? First issue is validity of 24th constitutional amendment made by the Parliament. And the second one, whether the Parliament has power to amend the Constitution. These two are the issues. You have to prepare like that. You have to select the issues like that to prepare a good notes. How much notes you have written is not important. What are the points you have written? Very much important. Next, third one, as I told, the arguments of the petitioner. Now, we find the facts in the case of that Kesvananda Bharti, as well as we identify the issues in the case of Kesvananda Bharti, and the third one, the arguments of the petitioner. The arguments of the petitioner is that he has the Constitution of India granted some fundamental rights to every citizen as well as to him also under Article 19(1). But this constitutional amendment 24th constitutional amendment overriding the fundamental rights granted to him under Article 19(1). So, the 24th constitutional amendment is illegal. That is his argument. SMS, his second argument is that Parliament cannot amend the Constitution. That is his second argument. Now, what are the arguments of the respondents? The arguments of the respondents are supremacy of the Parliament, means their arguments are that Parliament can do anything on majority because according to Article 368, Parliament has power to amend the Constitution. These are the arguments of the respondents. Now, hearing the arguments of the both sides, the Supreme Court ruled that, means now the fifth thing, that what I told, that you have to identify the 5 things to prepare the notes. The last one, that is the judgment. After hearing the both sides, Supreme Court ruled that Parliament cannot amend the basic structure of the Constitution. This is the judgment of the case. So, when you are going to prepare the notes, how you have to prepare the notes on Kesvananda Bharti's case means, first you have to write the facts of the case. The facts of the case are: the Kerala government made an act in the name of Kerala Land Reforms Act in 1963. Second one, according to this act, the Kerala government acquired some lands of a religious sect in Kerala. The chairman of that religious sect, named Kesvananda Bharti, challenged the action of the government of Kerala in the Supreme Court of India under Article 32. These are the facts of the case. Next, issues. Issues are: first issue, the Kerala government made this act, that is the Kerala Land Reforms Act 1963, based on 24th constitutional amendment made by the Parliament. Hence, the issue 1 is the validity of 24th constitutional amendment made by the Parliament. Second issue is that whether the Parliament has power to amend the Constitution. These are the issues. Now, the third one, arguments of the petitioner. Here, the arguments of the petitioner are: Parliament has granted some fundamental rights to him under Article 19(1). Not only to him, to every citizen of India. But the 24th Amendment of the Constitution made by the Parliament, overriding the fundamental rights granted to him by the Parliament, by the Constitution under Article 19(1). As well as his second argument is that the Parliament cannot amend the basic structure of the Constitution. These are the arguments of the petitioner. Next, fourth one, arguments of the respondent. Arguments of the respondents are: first one, supremacy of the Parliament. Second one is that Article 368, means the arguments of the respondents are: Parliament has power to amend the Constitution under Article 368, as well as the supremacy of the Parliament. After hearing both sides, Supreme Court passed the judgment. Fifth one is judgment. After hearing both sides, Supreme Court ruled that Parliament cannot amend the basic structure of the Constitution. Like that, you have to prepare the notes, because first you have to find out some hints, as I told you. Whatever I told, all those are hints. You can write the notes in detail using these hints. These hints will help you either to prepare the notes however you like, either in brief or in detail. If you want to write the note in detail, you can explain each and every hint in detail. If you want to write a note in brief, you can write. That depends on the total mark given to that question as well as the time. So like this, you have to prepare the hints as well as the important points to prepare the notes from the familiar cases. I will explain you in the next class about the another case, how to prepare the notes. Okay, bye.